Federal High Court sitting in Lagos has declared that it was unconstitutional for the federal government to conduct marriages, declaring as illegal and invalid, for example, all solemnization of unions at the Ikoyi Marriage Registry, Lagos. The court, presided over by Justice D.E. Osogo, heard that only the local government's marriage registries were empowered to do such by the provisions of the 1999 Constitution as amended. It submitted that the conduct of marriages and issuance of certificates were statutory, the job of the local government as provided by the law. The judge added that the act of the federal government through the Ministry of Interior operating marriage registries was beyond their powers and held that all marriages conducted by federal government registries or through their agents were illegal and invalid. He consequently ordered the closure of all federal marriage registries opened by the ministry, including that of Ikoyi Marriage Registry, with immediate effect. There has been a legal war between some local government areas in Nigeria against the federal government simply for the determination of who has the power to operate marriage registries, conduct marriages, and issue marriage certificates. For the reason, the local government had insisted that their powers to register marriages, which was statutorily provided, were being usurped by the federal government through the Ministry of Interior. This prompted the Eti-Orsa local government area of Lagos State to go to court, where it sought an order to take over the popular Ikoyi Marriage Registry, being operated by the Ministry of Interior, on the grounds that the federal government, through the ministry, had no business operating a marriage registry. The suit marks FHC/LS/CS/816/18, which had the Ministry of Interior and Attorney General of the Federation as defendants. They accused the ministry of usurping the local government powers to conduct marriages and issue marriage certificates. It also prayed the court to declare that the federal government has no business in the conduction of marriages and issuing marriage certificates, and therefore order the closure of all marriage registries opened and operated by the Federal Ministry of Interior or through their agents, including that of the Ikoyi Registry. At the end, the court granted their prayers, saying only the local governments have the power to conduct marriages in Nigeria. This day investigation revealed that the latest judgment was not the first to emanate from the court. On May 17, 2018, Justice Chuka Austin Obiozo of the same, while delivering judgment on suit number FHC/L/CS/1760/16, has each issued a restraining order against Ikoyi Registry from conducting marriages, saying it was unconstitutional for the federal government to perform the duties of the state and the local government. It said the marriage registries in the local government of Lagos State were the authentic and legally binding government decisions established to carry out such functions. Addressing a press conference afterwards, Lagos State Commissioner for Local Government and Community Affairs, Muslim Falami, said the judgment would be communicated to all stakeholders, including the embassies. For Alami said the decision of the court was supreme and legally binding on all, and that all marriages conducted and registered in any of the 20 local governments were valid in accordance with the Marriage Act. Particularly, he said the judgment will put a stop to the perception of superiority of Ikoyi Marriage Registry over the local government registries. We are going to use every available platform in the 5 divisions across the state to sensitize our people and inform them about this latest development from Ipe to Ikorodu, Badagry, Ikeja, and Lagos Island, he said. But instead of compelling with the decision of the court, the Federal Ministry of Interior went ahead. I beg your pardon, let me take it again. But instead of complying with the decision of the court, the Federal Ministry of Interior went ahead to establish more marriage registries across the country. Oh my God. I not understand. They say wonders shall never cease to end. So those people who don't marry before, they don't marry again. They don't turn single or what? This is not laughable. The judge is 100% correct. I hear your judgment, sir. It's actually the duty of the local government to issue marriage certificate, not that of the federal government. There must be proper adherence to the principle of separation of powers as enshrined in the Constitution. Kudos to the judge once again. Since all these years of wrongdoings, worth of all your past marriages conducted, their certificate, their payment, their photos, etc. This is just rubbish. I don't know about the feelings God regarding this. He is the only one to decide about that. Maybe the previous marriage will be pardoned, but definitely, according to the Constitution, only the local government has a right to conduct a wedding and issue certificate. Please go to Federal Registry because the court in Nigeria has long sold their rights and power for money. Nonsense country. These are some reactions by Nigerians. I'm dropping it here. What's your take? Kindly share your thoughts with us below the comment section. Don't forget to give us thumbs up. Thank you very much. Bye for now.